Yes, Lord Marks.
My Lord, I've discussed with Mr. Tannock the what I might call the fleet point, and it arose in this way, that before the recorder, it was simply accepted by counsel for help hire that there was available a fleet. Sorry, counsel from Ms. Armstead, that there was available a fleet.
Yes, I was asking you to, not as it were fact specific to this case, just whether the consequence of the way you put it was that in every case someone wanted to claim a Clause 16 contractual liability, they would have to go to their hirer and get the hirer to produce all the documents that demonstrated there wasn't a fleet, if it be the case.
Yes, but my Lord's assuming a slightly different factual position, because in general, as your Lordships will know, and my Lady will know, as in this case, there is no attempt to collect from Ms. Armstead. There's no evidence that she ever paid this liability, and indeed there was only a demand for it after some 2 years. So broadly speaking, it is the general position, as in this case, that the hire company is attempting to recover its contractual rate and using the name, as they're contractually entitled to do, of their hirer to recover. Yeah. And one of the points in this case is, of course, that Ms. Armstead suffered no loss. The loss is, if any, is help hire's loss. And indeed, a point is made that Clause 16 specifically refers to the credit hire rate as damages for loss of use. And we say that that is an artificial approach. And as Lord Justice Dingham suggested, it would always be possible to show the rates of use of help hire's fleet, as it would with anybody else's fleet, in order to show what might actually represent the revenue that they were earning. But the other point we make is that the loss is only a loss of revenue if that revenue was earned. Otherwise, the value of having the car simply sitting idle is simply represented, as in Beechwood, by the capital cost tied up in the car.
But the Clause 16 is contractually valid.
Yes, I've conceded that for the purpose of this hearing, that's right.
I mean, so it's not challengeable as a penalty clause, it's not challengeable as an unfair term under consumer rights legislation. So it is a contractually valid.
Yes, we haven't pressed those points, even if they might have been at one stage available to us.
So Ms. Armstead's loss is the liability to pay under a valid contract.
Ms. Armstead has a liability to pay under a valid contract. That is
the fact that she herself has not suffered any loss of use, or help hire has not suffered any loss of use, is neither here nor there. We're talking about her loss. Her loss is the contractual liability.
Well, my Lord, that's entirely... it's correct as a matter of analysis up to a point, but it's offset by the fact that the reality is that that is never collected from her. And the only way that the credit hire companies collect on their liability is by suing the negligent driver. So the person who is
well, they're not suing. They may be using her name to sue, but
yes.
We have to, legally, it's her claim, isn't it?
Yes.
Being made.
Yes.
And if she recovers under her claim, they'll collect it from her.
It'll be paid to them, yes.
Not that they never collect it from her. It's just they wait till she recovers it from the negligent driver.
Mr. Gillespie's insurers, my clients, yes, RSA, will pay the liability.
Well, insurers standing as it were.
Yes.
So I come back to the point. The loss we're talking about is her contractual liability under what you've conceded to be a valid contractual obligation to pay under Clause 16. So why can't she recover it?
Well, because it doesn't represent an actual loss of use.
Why does that matter? It's a loss to her, a contractual liability.
Well, my Lord, where is the... sorry, I didn't want to question you. In the Dimmond and Lovell case, the House of Lords held that the credit hire was not recoverable, the credit hire charge was not recoverable from the third party. Although I've drawn the distinction between a Clause 16 liability and the credit hire liability, the credit hire liability is also a contractual liability. It's a contractual liability to pay the credit hire rate. And in Dimmond and Lovell, the House of Lords said you cannot recover that as damages for loss of
But
use.
is that kind of credit hire liability something which is entered into prior to the negligent event? In that case, the credit hire liability is incurred, presumably, after your car's been damaged for the purpose of having something to drive.
Securing a car.
When the negligent driver has knocked your car off the road.
Yes.
And the reason why the court says, well, the full credit hire liability isn't recoverable by somebody who could have afforded a non-credit hire contract is presumably because they haven't mitigated their loss.
Well, my lord, it's never put in those terms.
No,
the terms in which it's put. I'm sorry, my lord.
It's put as a betterment, isn't it?
Yes.
That
well, my lord,
by obtaining the credit, they have achieved a better.
What Lord Hoffman says is you have to. First, they say that the need for a car is not a self-proving proposition.
Yeah.
Then Lord Hoffman says you have to work out what are the benefits that she has obtained, that the hire has obtained, which of them are recoverable as loss of use, and which of them are extra benefits.
Yeah.
But that's all in the that's not a case where a pre-existing contractual liability has been triggered by the.
That's perfectly right.
Yeah.
But the question is whether the fact that it's a pre-existing liability makes any difference as a matter of principle, where there is a contractual liability in an ordinary credit hire case, whereas in this case, there is a coincidental extra factual feature, which is that the luckless Miss Armstead had 2 accidents, and that the Clause 16 liability, a contractual liability, arose as a result of taking out the credit hire contract after the first accident.
At the moment,
I would suggest that
Diamond and Lavelle helps you on the point I'm putting to you. Seems to me distinct.
my lord, I'm sorry.
A different factual scenario, Diamond and Lavelle. It's not a case where we're dealing with a liability, or the claim is not based on my loss being a contractual liability.
My lord, I think it is. It's a contractual liability of a slightly different type, but it's under exactly the same type of contract, which is a credit hire contract. The factual difference is the difference which my Lord Briggs draws out, that this is because it's a Clause 16 liability arising after the first accident.
Yeah.
When we were shown other clauses like Avis and so on,
Yes.
Those are in regular hire, ordinary car hire contracts.
Yes.
Would the rate be correspondingly lower because it wouldn't include a credit element? Is that?
Yes.
So
The rate is.
would not be analogous.
Yes, we were told the figure was half. It's in fact a little
those
less.
Bar charts or whatever give an idea of it. Is that?
Those bar charts are exactly accurate. They represent, and the authorities are that you take these. This is Stevens and McBride, which are the two with which Mr. Williams and Mr. Smiley's note were concerned. Say that you take the lowest basic hire rate BHR in order to calculate the actual loss. Now, those aren't the subject of this appeal, is our position. But yes, the comparison is between the basic hire rate, which is the lowest of the enterprise dollar and other six.
So suppose this was not a credit hire case, but suppose that the car that Ms. Armstead had been driving was an Avis or other rental car. What would your submission be about the recoverability of that charge?
Well, that charge will be in the same capacity. You'd have to assess it for reasonableness.
Yes.
And when we come to Network Rail, which I shall do relatively shortly, That is authority that you cannot take the contractual liability between the hire company, whether it be an ordinary hire company or a credit hire company, and the hirer as definitive for the purpose of claiming against a negligent driver in tort. Now, it is perfectly clear that as a matter of fact, if you've established it's reasonable to go out and hire another car, which you have to, and you've hired a car at the basic hire rate, then it's going to be very difficult for the third-party driver to contest that, and that's what all the other cases establish. What Diamond and Lavelle establishes is that you cannot claim the credit hire rate unless it be the case that you can set up a case of impecuniosity. Impecuniosity hasn't been raised in this case at all. That's the authority of the Lagdon and O'Connor case, which provides that in cases of impecuniosity you recover the credit hire rate because it's reasonable to get those extra benefits because it's the only way you can get a car.
Yeah.
This is all about the conduct of the victim of the tort as a result of having been damaged by the tort. It's the claimant, if you like, bailing him or herself out of the consequences of having had a car run into by a negligent driver. In this case, the reason why the claimant is on a credit hire contract has got nothing to do with this accident. It's because of an earlier accident to a car which was damaged by some completely different tortfeasor. And she, under the arrangements for coping with the fact that her car was off the road, ends up with a credit hire contract under which she's hiring the car. Now, there will be drivers on the road with credit hire contracts under which they're hiring the car, which therefore have clause 16 at the credit hire rate rather than the basic rate.
Yes.
There will be drivers out there under ordinary hire contracts driving cars at where their version of clause 16 will be at the ordinary rate.
Yes.
But why doesn't the person who runs into the person, unless it's wholly unforeseeable that the person whose car you run into is on a credit hire arrangement so as to be able to use that car, why doesn't the tortfeasor take his victim as he finds him?
Well, because on the authorities, the loss of use is not represented by the clause 16 liability. And the
but
clause
it isn't a loss of use in that situation, is it? It's a clause 16 liability.
Yes.
It's a contractual liability.
He's got this car on terms which include clause 16.
Yes, certainly.
It's nothing to do with his loss of use of that car. It happens to be on those terms because he's lost a previous car, which is wholly irrelevant.
Yes, but he's only gone out to get the credit hire use. He's only gone out to get the credit hire contract with the clause 16 liability at the higher rate because he's chosen to do so. So the Diamond and Lavelle considerations apply equally to his second contract as they would have applied to a hirer's first contract.
Am I right that you've got two quite different points that you're making? One, your loss of use point, which I think you were making before lunch.
Yes.
Is that unless you can show that the car hire company didn't have spare cars, you suggest that they can't claim more, the person can't claim more than the car hire company has lost.
Yes.
And you also have an argument which is quite different, which is that because in this case there's a credit element, and it's not just the cost of the car, that credit element shouldn't be recoverable. And I think you may have rather sold out the first argument when you accepted in answer to me that as long as, if it was a case of a normal rental car, provided it was a market rate, it probably would be recoverable. I think that's inconsistent with your loss of use point. But you've got two different arguments. One is that loss of use sets the limit, and the other is that you can't get the credit element, but you can only get the hire charge.
My lord's quite right, but the company still has to establish, in order to get loss of use, it still has to establish that there are no cars, that car would have been rented out, which was my...
But do you agree that they are two different arguments that you're making?
Yes, but I think there are three.
Right, what's the third?
The first is the one I was making before lunch, that the hire car company has to show that it would have been hired out.
Yes.
That's the loss of use,
Yes, that's one.
Yes.
And then the other is...
The second one is that you have to show that the loss of use is reasonable. That's on the authority of what Lord Justice Pill says in Network Rail.
So is that separate from the first point?
Yes, it's that the rate has to be reasonable.
It's different. I mean, Network Rail doesn't fit with your first argument, does it? Because there's nothing about loss of use and the charges for the network that the rail companies were making.
No, the applicability of Network Rail is to the question of whether a contractual liability represents a reasonable assessment.
Yes.
Or that you can't rely just on a contractual liability.
I think
you have to get to reasonable assessment as well. So you've got to prove two elements to recover.
I think Network Rail's authority against your first proposition, because the damages there were not limited to any claim for loss of use by the companies which made the claim against Network Rail had suffered.
It didn't arise.
No.
Because Network Rail themselves had suffered the damage. They themselves had suffered the obligations to the train operating companies.
Yeah.
And it was agreed that the train operating companies, the liability to them was a reasonable assessment of their loss.
Yes, and that's all that mattered. And whether it was characterised as a loss of use of property or some other loss didn't matter. Just as it wouldn't matter here whether the charge that Ms. Armstead has to pay is somebody else's loss of use or charge levied for some other reason.
Well, except, of course, that help hire don't suffer any loss at all if the liability isn't a real one.
Right, so you say it doesn't have to be a loss of use, it has to be ultimately somebody's suffered a loss.
Somebody's suffered a loss. And what we've got here is the position where the only person that's suffering a loss is Mr. Gillespie or his insurers, because the credit hire amount is being claimed against Mr. Gillespie in the absence of any proof of loss. My further point, though, which I said three arguments, I'm sorry.
I mean, Lord Marks, I'm getting quite confused, I'm afraid, and I'm sure entirely my fault. Could we just run through these 3 points again so that I can be sure I understand them, please?
So the first is that it is incumbent upon a claimant in negligence to establish a loss. And that's in any case, and that's from first principles.
Yes.
The second is that where a claimant in a case of negligence claims that they have incurred a liability, contractual liability, that is half the battle. They also have to win the second half of the battle, which is in showing that that liability represents a reasonable assessment of loss. And that follows from Network Rail and what's said by Lord Justice Pill. The third is that
of loss by the other contracting party.
Yes.
yes,
Must be.
yes. The third is that where a claimant in a credit hire case claims a credit hire loss at a credit hire rate, that is not recoverable because it doesn't simply cover the cost of providing a car, which is recoverable on the basis of an ordinary market rate, which is called the BHR, the basic hire rate. It also recovers items like the cost of credit, that is, not have the hirer not having to pay for the car, the cost of collection, because the hire company is going to have to pay for the cost of the litigation in order to collect from the negligent driver, and deferral of payment and that sort of thing.
So, on your first...
And uncertainty, there's a risk element as well.
On your first, it's incumbent on the claimant in a negligence claim to establish a loss.
Yes.
I mean, that's presumably satisfied here because the claimant has a contractual liability under Clause 16.
Well,
Is that right? I mean, so that one
I
isn't
mean,
really an
Ms.
issue.
Armstead has a contractual liability.
She's incurred a loss.
She's incurred that liability.
That liability.
The problem with that is that the collecting party is help hire,
Yes.
collecting on her liability, which exceeds its loss.
Yes, but it is her liability
I understand that.
to help
Yes,
hire.
yes.
And I mean, unless you're saying that's a sham or something, and there's no finding about that, that is her liability.
That is her liability. I can't get away from that.
All right. But I think I understand the way you put your second point, and you're going
Yes.
to take us to Lord Justice Pill in
Yes.
Network Rail. But the third point I'm finding a little bit more difficult, because you say where it's a credit hire case. I mean, this is still a negligence case. So can you sort of...
So can I take you to
Where-
what Lord Hoffman said in Dimond and Lavelle, which is...
But yes, I don't... But before you do that, can I
Yes.
ask you this? Supposing it is the case that the claimant here, having had her own car damaged, couldn't afford to hire a car on standard terms, and so did have to take out a credit hire agreement, would her claim now succeed so far as this ground 3 is concerned? So
That's the effect of Lagden and O'Connor.
see. So
Well-
so whether the contractual liability can be recovered by her depends on whether she was forced into the contract which contains clause 16.
Exactly.
So even if
If
she's
she
one of
has-
the fools between entering into that contract and having her car run into by the negligent driver, she's still okay in terms of recovering the credit hire charge rate.
She recovers the credit hire charge rate under Lagden and O'Connor if she is impecunious. And what was said in Lagden and O'Connor in the Supreme Court was that she then has no choice
Yes.
but to accept the obligations of the credit hire agreement.
And you're saying, as I understand, it shouldn't make a difference whether she enters into the contract after or before the accident. Either way, one's got to work out what element of cost, as it were, is attributable to the damage and what is attributable to her choices that are or matters that are other than the damage itself.
My lord, exactly. And
It's not just a timing question, is it?
well, that's the question which I think divides us, my lord.
Because you say it's just a timing question, but the contract she makes in this case, the credit hire contract, wasn't to deal with the consequence of having the car run into by your insured's client. It was to deal with the consequences of the previous accident. It was the terms upon which she was driving the car that was then negligently run into. Whereas the sort of cases you're talking about, which the credit hire cases aren't just, it's not just that the contract is later, it's a contract taken out to deal with the consequences of the accident for which she's claiming compensation. This contract is a contract not to deal with the consequences of this accident. It's simply the contract by which she happens to be driving the car when she's run into.
My lord, that's certainly a factual difference.
That's not just a timing difference, is it?
But I'm completely at a loss to see why your lordship should regard that as making the difference between recoverability from a tortfeasor, who is a stranger to the contract in both cases, and irrecoverability from that tortfeasor. That's, my lord, where I'm not...
You're saying, are you, that what she did was unreasonably subject herself to this clause 16 liability, unless she can show that she was impecunious and had no choice. Would
Yes.
that be one way of putting it?
Yes. And the authority...
As between her and the defendant, not necessarily unreasonably from her own point of view.
Absolutely. Nobody is suggesting that anybody hasn't the right, the contractual right, to enter into whatever contracts they like. Ill-advised, as my Lord Burroughs suggested earlier, or well-advised. That doesn't matter. She may well choose to take the risk, but that doesn't mean that she can pin all the liabilities that arise under that contract on the tortfeasor, who is a stranger to those contractual arrangements. My Lord, perhaps I can simply...
In reality, when the first accident occurred in this case, the claimant entered into a credit hire contract, presumably because that was what her insurers offered her. They said, well, we'll arrange to pay for you to have a credit hire contract to have an alternative Mini. I mean, she didn't go out and say, well, do I go to Avis or Help Hire? Did she? Or
I think
is that how it works?
Conjecture, unless...
That's the trouble here, isn't it? I mean, none of this was explored at trial. It wasn't part of anybody's case that this contract with Help Hire was itself, as it were, from inception, a reasonable or unreasonable contract.
Yes.
This wasn't. There are no findings about, no consideration of that.
Nor indeed, I think, was there any finding about whether it was the insurers, as my Lord Briggs suggests, that got her into this contract
but we don't
on her
know.
own.
I mean, we know nothing at all about the genesis of this contract.
I'm going to ask Mr. Tannock very quickly to look at Miss Armstead's statement, which is in the bundle.
It probably doesn't matter, actually, who it was.
I'm not sure it does matter.
I don't think the result can turn on it.
What I would invite you to do, because time constraints, is to look at Lord Hoffman's analysis in Dimmond and Laval as to how you deal with the additional benefits, which is the way he puts it.
That's at page.
And they're at 585
Thank you.
to 586. And Dimmond and Laval is authority from the House of Lords that you cannot recover the credit hire rate, and Lagdon and O'Connor comes along later as an exception to that in cases of impecuniosity. And I accept that it may be that there's some infelicity about the position of those two authorities, but that is the state of the law and decisions of the House of Lords and the Supreme Court, and nobody's challenging them. My Lord, if I could move on to a more general point, which is in a sense a policy point, but it deals with Mr. Williams' submission that it was fine to have swings and roundabouts, and there may be an element of overcompensation in respect of the Clause 16 liability. There may not, because the 30-day limit may kick in and therefore reduce the compensation to below the actual loss. That is, I say, wrong as a matter of policy, but also wrong as a matter of principle, because damages in tort are not expected to reflect what contractual parties might agree. And he draws the analogy with liquidated damages. They are expected to reflect, and should as a matter of principle reflect, the actual loss sustained by the claimant as a result, in this case, of the accident.
As a result of?
In this case, the accident, but the tort.
But it comes back to the same point. I mean, she has suffered the loss because of the liability under Clause 16. I think the swings and roundabouts was put as a riposte to the suggestion that it was an unreasonable clause.
Exactly. But that's in the context of a concession.
Not going to actual loss, but going to whether it was a reasonable or unreasonable, a pre-estimate of loss.
Yeah.
Yes.
The sort of network rail type
yes. My point is that the question of reasonableness has to be assessed as between claimant and tortfeasor on the loss actually sustained. Network rail sustained the loss which the court specifically held was reasonable.
But that was a contractual liability.
A contractual liability.
They didn't sustain a loss. They sustained a contractual liability to pay. That was the loss.
That's absolutely right. But the agreement was that was an accurate assessment of the loss sustained by the train operating companies as a result of the inability of Network Rail to provide a railway.
But part of the reasoning, at least, was you didn't have to parse the very complicated loss of the network of the companies in detail. It was sufficient that on a fairly broad brush level it was a reasonable assessment or estimate.
There was certainly...
And it's an open argument, isn't it, if we were to get into the detail of it, which I'm not sure we can or should, that there's a sort of swings and roundabouts element to the reasonableness of this clause.
There was certainly an element of, in Network Rail, you had to do your best. And it was, but there was a positive finding that it was reasonable. And I'm going to take you now, if I may, it's slightly out of order, but probably best to do so, to what Lord Justice Pill said, because it's our submission that is at the heart of this. And it's at page 749 to 750. My volume 2. Mr. Williams read 68, and I need to go from 70 to 71. So, from 69 to 71. Attractive as is the simplicity of a solution by which the tortfeasor is liable to pay whatever the respondents and the TOCs agree. And that's my latest point, that's the contractual liability, as between them to be reasonable compensation. Such an agreement does not, in my judgment, necessarily bind the appellants as tortfeasors to pay the agreed sum to the respondents. It is not open to a party to dictate to the whole world the extent of tortious liability and what is reasonably foreseeable and not too remote in order to achieve what it regards as a satisfactory contract with a third party. And that's at the heart of my submission. In order to achieve, it could lead to ever more ingenious attempts to attribute possible losses to a tort and would be inimical to the simple solution desired. There could be sound contractual reasons for providing passengers with compensation, for example, for the consequences of lost business, or medical appointments or job interviews, but such consequences are likely to be too remote to charge to a third party in tort. Making a contract does not confer a license on the respondents to charge to a tortfeasor whatever type of financial loss and whatever quantification of financial loss is included in the agreement, provided it is reasonable between the contracting parties. And the importance of that is it may be reasonable between the contracting parties, but nevertheless irrecoverable against the tortfeasor. That is particularly so when the terms of the contract are influenced by government policy aims and so forth. And at 71, courts have been prepared to analyse contractual arrangements between the victim and a third party when deciding the extent of the tortfeasor's liability. With differing results, that was done in Dimmond and Lavelle and the Sandham and Compromise case. In Dimmond and Lavelle, for example, the claimant chose to contract with a specialist vehicle hire company. The additional cost could not be recovered from the tortfeasor. It makes no difference, in my judgment, that the respondents are monopoly suppliers of the use of railway tracks and there cannot be said to be a market. The courts will intervene to assess the reasonableness as between the claimant and the tortfeasor of the losses specified in the contract between the claimant and a third party. Lord, if I could take you to 757, And invite you to look through paragraph 8, paragraph 98, I'm sorry, as to what Lord Justice Morbeck said. It's really just the first point. I think it worth reminding oneself at this point that it has been accepted by all concerned, including the appellants, that the Schedule 8 payments represent the best assessments in financial terms that can be made of the commercial damage caused by the train operating companies by disruption to rail services. As Lord Justice Pill explained, they comprise two elements. So, my lords, where that takes us is that to the two-stage approach, and the two hurdles that have to be surmounted by a claimant in tort, where there is a contractual liability. The first is to show what the contractual liability is, and to answer the point that my Lord Burrows has put to me, that liability is unchallengeable as a contractual liability. But to achieve recoverability against the tortfeasor, it is necessary to show that that is reasonable. And my lords, in connection with that, Ms. Armstead conceded in the Court of Appeal that it was incumbent upon her to demonstrate that her loss was reasonable before it would be recoverable, and that's recited in the Court of Appeal's judgment by Lord Justice Dingemans at paragraph 49.
Well, maybe she did, but if the comparison is with mitigation, and it really shouldn't make a difference whether the liability is incurred before or after the damage, might not the principle be that it's for the defendant to show that it's unreasonable? It is in terms of mitigation, isn't it? If an expense which is incurred after the tort is committed by the claimant, if it's to be said that wasn't caused by the loss but by the claimant's choice, then it's for the defendant to show it was an unreasonable step taken.
Well, my Lord,
might not that be the same here?
I don't accept that, because the question of mitigation arises where the defendant is saying that you should have taken a cheaper option and proving what it is. That doesn't alter the primary obligation on the claimant to show the loss and that the loss is reasonably incurred.
It does. The claimant has to show the loss.
Yes.
That it's caused by it's a response to the tort, but then it's for the defendant to show that it was unreasonably incurred. That's Roper and Johnson and many other cases.
Well, I follow the point your Lordship is putting to me, but the question here is that, or the point here is that the need for the car and that the loss is in the first column rather than the second column. In other words, it is in the what is the loss.
Well, I don't accept that, because you've already agreed that the loss for the claimant is her liability, and the question then is to what element of that is caused by the damage and what element is, as it were, extraneous sum, if you can parse it up. And it might be said that a mirror image of mitigation is that it's for the defendant to show to what extent it was not a reasonable consequence of the accident.
Well, my Lord,
and that the law would be that would be a principled approach to take for the law.
And isn't that the way that it was approached in Dimmond and Lovell by Lord Hoffman? Because on the pages that you invited us to look at the bottom of page 585, he said that where he thought the Court of Appeal had gone wrong was in not looking at the additional benefits obtained as a result of taking reasonable steps to mitigate loss to be brought into the calculation of damages. So it was a mitigation point rather than a proof of loss point.
Well, your ladyship is certainly right in what you say about what Lord Hoffman said, but it is certainly the case that in Dimmond and Lovell and all the other credit hire cases, you cannot recover the credit hire charge as a first step. You can recover the credit hire charge only if there is impecuniosity.
Can I just go back to Network Rail, which is,
My Lord, yes.
although it's not about car accidents, it is about a pre-existing contract.
Yes.
It's about contractual liability and is very important in this case, I accept
It
that.
looks as if one looks at things like paragraph 94, which is Lord Justice Norvick's recitation of the submissions, and paragraph, that passage from Lord Justice Moore that you helpfully, to which you helpfully draw our attention. It looks as if where it's a pre-existing contract, if it contains a provision which isn't a reasonable assessment of the loss, it may be said to be not reasonably foreseeable. In other words, this issue goes to foreseeability.
And that's exactly why the claimant made the concession that he did.
Yes, but
And it's recited as that, yes.
I mean, I understand that analysis. My question here is, we have a form of hire contract in which the clause 16 rate simply follows the daily hire rate as night follows day.
Yes.
And it is, I think, common ground and recited in the statement of facts and issues that is standard form across the industry. In other words, whether it's a Avis type contract or a credit hire type of contract, it's standard form for the clause 16 rate to follow the daily hire rate, the primary hire rate in the contract.
Yes.
Now here,
It's certainly accepted that
here she's driving
form is
a
complex.
car under a credit hire contract. Nobody apparently is criticising her for driving a car under a credit hire contract. And she made that decision before coming into any kind of proximity with the defendant. Why is it not foreseeable that A, somebody would be driving a car under a credit hire contract, and B, that if they were, the contractual liability which they would incur as a result of being run into by somebody else's negligence in a way that didn't make the car unusable would be the same daily rate as they were paying under the credit hire contract? In other
Well,
words,
I think the answer...
the difference between this case and Network Rail is this is a bog standard clause contract, whereas Network Rail is about the most one-off type of contract anybody's ever seen.
I completely accept that distinction, but the Network Rail is plainly germane because it contains the contractual...
Germane, because it shows that all this goes to foreseeability.
Yes.
Unless it goes to some different principle of the law which isn't about foreseeability. And if it only goes to foreseeability, then why is a bog standard contract of this type unforeseeable?
Well, the reason, answering my Lord's first question, the reason why nobody's criticised her for the credit hire rate in this case is because the credit hire rate's never been an issue. There's never been a claim for the credit hire rate in this case.
Well, the clause 16 rate.
The clause 16 rate is the clause 16 liability. I'm so sorry. Clause 16 liability is tied to the credit hire rate, yes. And that is, as your lordship put it, bog standard.
Well,
that I entirely accept.
That's the measure of her claim.
That's the measure of her. That is the measure of her claim, and that is the measure of the contractual liability of which she seeks to recover.
Yeah, but why is that unforeseeable? I mean, in Network Rail, if the Schedule A payments were not a reasonable pre-estimate of the TOC's loss, then it appears to be submitted and accepted, I think, by the court, that then they wouldn't be, even though a pre-existing contractual liability, one which is a foreseeable consequence of the bridge bash.
Yes, I don't think they're saying that therefore that reasonableness and foreseeability are the same thing. Indeed, I would submit that they are not. What the Court of Appeal held in that case, and the reason for Mr. Williams' concession, was that if the damages, if the quantification of the damages was unreasonable, therefore that is unforeseeable, because it is not foreseeable that somebody will go into not foreseeable that somebody will go into an unreasonable assessment.
Well, I can see that in relation to a one-off contract. I just find it difficult to understand in relation to a bog standard contract.
But it is, I think the difficulty here is that it was a concession made in the Court of Appeal. I mean, I've got paragraph 49 open.
Yes.
And you're right to draw attention to the fact that it said Ms. Armstead accepted she could not claim damages under Clause 16 if the losses claimed did not represent a genuine and reasonable attempt to assess the likely losses to be incurred as a result of loss of use of the motor car. Mr. Williams, counsel, made this concession based on the decision in Network Rail.
Yes.
So there we are. I mean, that's the position in this case, isn't it? You would say.
Yes.
I mean, whether the concession was rightly made or not, it was made.
Yes.
But at the same time, it's right to say, isn't it, you were not arguing in the Court of Appeal that it was not a reasonable assessment of likely losses. Am I right in saying that?
No, I don't think that's right.
But what was the concession you made in the Court of Appeal? You were not running a positive case that the clause was unreasonable, I think.
We were not running a positive case, and we did say in that hearing, though I haven't attempted
you can't
to revive it.
reopen it up here.
That it was not unreasonable as between Ms. Armstead and Helper.
Where is it stated? I think it's in Lord Justice Dingaman's judgment somewhere.
It's in the skeleton argument as well.
Yes, it
I think
is.
it was in your skeleton
It's
argument.
in our skeleton argument
it's not.
as well.
I see. I see.
I'm looking for it.
Mr. Tarmac will find it and we'll come back to it. But it was exactly that. It was as between the contracting parties.
Not unreasonable.
It was not unreasonable. 368. Thank you.
Right. So was there argument in the Court of Appeal about whether Clause 16 was a genuine and reasonable attempt to assess likely losses? The submissions made on that topic to the Court of Appeal?
Well, there were submissions made to the extent that it was unreasonable and didn't represent the losses, yes.
It may turn on the burden of proof, this point. Who had the burden of proving either that it was reasonable and genuine pre-estimate or that it wasn't? Because it's not for us to start making findings of fact.
No, absolutely.
Right. And it was made.
But the evidence we have on the reasonableness and otherwise is the Pretorius evidence. And since this wasn't an impecuniosity case, this was a case to which Dimond and Lovell applied. And we say that the difference between 600 and something pounds, which was the lowest BHR, and 1,750 pounds, made that recovery unreasonable. But we go further than that. We also say that in the absence of evidence of usage, then the recovery of a full retail charge-out rate was unreasonable. And that was certainly argued, and that found its way into Lord Justice Dingaman's judgment. So what was the page number? 368. So it was paragraph 42 of our skeleton,
This is in the Court.
368 in the Court of Appeal. And, I mean, bluntly, we say that Ms. Armstead has attempted by some sort of forensic sleight of hand to make this concession go far further than it does. In the premises, although the respondent advances no positive case in this respect in this hearing, the respondent has consistently taken the position at the county court level that clause 16 would most likely be unreasonable with respect to Miss Armstead and subject to statutory control. And that's under the heading of the paragraph, which says unreasonable as between Miss Armstead, the appellant, and the hire company. And it simply cannot.
As noted above, the recorder concluded that as between the appellant and your insured, the losses arising under clause 16.
Yes.
Well, I see, were unreasonable.
Yes.
I see, sorry.
He concluded that they were unreasonable, and that was on the basis of the submissions made to him. And that was mirrored by the Court of Appeal in Lord Justice Stingerman's judgment.
What's the last sentence of paragraph 42 about?
So that is, that's...
No positive case in this respect in this hearing. R has continually taken the position in the county court level that clause 16 would most likely be unreasonable with respect to A.
Yes.
And subject to statutory control.
That's a reference to the reliance on the pleaded case that the clause was unfair as between the contracting parties.
Yes.
You're saying you're not making that. You're not taking that point. But
Not
you're
taking
saying it's
that.
unreasonable as between
Yes.
the defendant. And
Yes. I'm saying that that cannot cover the position as to recoverability against the tortfeasor. And if I can take you to Lord Justice Stingerman's findings on reasonableness. This was pursuant to submissions that Mr. Tannock made in the Court of Appeal. That's at page 133.
Sorry, which paragraph?
Paragraph 55. Thirdly, clause 16 of the help hire agreement did not represent a genuine and reasonable attempt to assess the likely losses to be incurred by help hire as a result of loss of use of the motor car. The full loss is claimed for a credit hire daily rate, even if the sum is reduced to the daily rate for periods of hire in excess of 28 days as contemplated in paragraph 10 above. As Lord Hoffman pointed out in Dimmond and Lovell, the credit hire rate included charges for providing credit hire for the hire charges. There was no guarantee that someone such as Miss Armstead would be impecunious and so entitled to recover that credit hire rate as opposed to the basic hire rate, compare Langton and O'Connor. And the credit hire rate included charges for the costs of bringing claims to recover the damages on behalf of Miss Armstead. In fact, with a 24-hour notice period in the help hire agreement, it seems that the loss of the ability to hire during the period of repair would always be help hire's loss, although recovered by Ms. Armstead on help hire's behalf. Although Mr. Williams is right that many hirers would be unable to afford to hire a car in addition to their usual outgoings, if it were to be damaged in a road traffic accident, and so able to claim the credit hire rate, that's a reference to Langton, it would not be the case that every hire made by help hire would be at the full credit hire rate. An average daily hire rate for the Mini Cooper motor car achieved by help hire might have provided the answer to this. Further, it seems very probable that there would have been other cars available to be hired by help hire in the place of the Mini Cooper motor car for at least some of the period of repair. This might be proved by the percentage net usage rates for help hire's cars. This would have led to a reduction of the rate claimed in clause 16 of the help hire agreement. The actual assessment of damages for loss of use by a party, such as help hire, will be for decision in future cases. But this analysis shows that clause 16 does not represent a reasonable sum to claim against RSA's insured driver. And in connection with this and with the burden of proof point, just a reminder that in Beechwood, the Court of Appeal quoted Lord Mustill and Giles and Thompson. That's page 434. The need for a replacement car is not self-proving, and they approved as a long-established principle that a claimant must prove that a replacement car was reasonably necessary.
That's at paragraph, what did you say?
That's at page 435, paragraph 28. 25 and 28, I think. 434, 25 and 28.
Oh, yes.
And in relation to impecuniosity, I've read to you the passages that Mr. Williams relies on for his assertion that lots of hirers wouldn't be able to afford cars and so forth. But in this case, there's no question of impecuniosity that arose. It's not open, we say, that to Mr. Williams to argue, as he does, that Lagden and O'Connor doesn't represent a narrow exception to the default recovery of a basic hire rate. And probably most citizens would be unable to afford to hire a replacement car from a conventional hire provider after suffering an accident out of the blue. Now, that assertion found favour with Lord Justice Stingemans. He said, well, Mr. Williams may be right about that. But we say that Lagden and O'Connor does make it clear that where a claimant establishes the reasonable need for a replacement car, then in the ordinary case, a non-credit hire rate is recoverable as damages for loss of use. But if a claimant is impecunious, as in that case she was, and therefore has no choice but to hire a credit hire car, then the credit hire rate will be recoverable.
But if the principle is that the Clause 16 type damages must represent a genuine and reasonable attempt to assess the likely losses,
yes,
it's irrelevant whether the hirer is impecunious or not, isn't it? You're looking at whether what Clause 16 is doing.
yes.
I mean, it's a different point that if you're impecunious, it may be reasonable for you to hire a replacement vehicle on
yes.
credit hire terms. But if the question is what is the quality of the Clause 16 type damages, well, that it's the same issue, whatever the type of contract, isn't it? Supposing it was a standard hire contract, it would be the same question, wouldn't it?
I entirely accept that, but that can only be applicable as between Ms. Armstead and Help Hire.
No, I think what I'm actually looking at is as between Ms. Armstead and the tortfeasor. Because as I understand the point, it is that where you've got a liquidated damages clause, as it were, it's got to represent a reasonable pre-estimate of loss.
As a matter of contract, yes.
I mean, you could actually object to recovery under the equivalent of Clause 16 in a standard hire contract, because you might be able to say, mightn't you, well, even recovery of the daily standard rate is too much.
Yes.
Is that right? I mean, that's the logic of your submission
yes.
here, isn't it?
If it was absolutely, yes, it is. If it was absolutely clear, and a tortfeasor and a claimant was in the position that they had a stack full of cars and they hadn't lost anything at all, just as in the West Midland bus case, where they had lots of other they had lots of other vehicles and so forth. And the bus case isn't exact because it was a maintenance case, but nevertheless, the principle is there. If there is no loss of use is what is recoverable from the tortfeasor.
You slightly gloss that, don't you? Because I take you to accept that it may be reasonable to have a standard clause that takes the average, as it were, situation, and that uses that as a pre-estimate of the loss, on the basis that sometimes we'll have a spare car available and sometimes you won't, and maybe you could have a clause that was reasonable because it represented a sort of compromise situation.
Well, my lord, if I may say so with respect, that is elegantly put, but it doesn't take into account the difference between a recoverable loss in tort, which has to be a loss sustained by the claimant, and what may be acceptable in contract,
but I
which
thought
is a genuine pre-estimate.
I was taking it from the Network Rail case.
Yes.
I'm taking from the Network Rail case that foreseeability in tort, this is your proposition, involves showing that your liability to the third party was a reasonable and genuine pre-estimate of loss. And if you transplant that here, what I'm suggesting is it would be okay for the Miss Armstead or Help Hub,
yes,
if they're the ones behind it, to show that our clause 16 may not be the actual loss in this particular case, but it's a fair pre-estimate of the loss that we're typically going to suffer, and that therefore it would not necessary to look into whether they had a spare car available or they didn't in this particular case, but one could take an average, let's say that half the time we have a spare car available and half the time we don't, and I'll factor that into the clause, and it's a reasonable pre-estimate. And so it's reasonably foreseeable that they might have a liability of that kind, and away the claim goes. Is there anything wrong with that?
Well, my lord, I think as a matter of principle there is, because
there is something wrong with that.
I think there is something wrong with that, and the what is wrong with it is that the phrase reasonable pre-estimate can be used in two ways. It can be used in a contract in the liquidated damages sense, where the parties agree a reasonable pre-estimate because they can't actually determine what the damages are likely to be. In the Network Rail context, in the context of the claim in tort, what is meant is a reasonable estimate of the loss that is going to be suffered as a matter of fact by the train operating companies. So it's not...
That's the same thing, isn't it?
It is the same thing in that case. But the routes that you get there, the routes by which you get there are slightly different.
But your route would require you, wouldn't you, to calculate the actual loss and then say whether the contractual provision was a reasonable estimate of it? Or reasonable pre-estimate?
Not necessarily
so
to require...
lead you into the very problem you want to avoid with a liquidated damages clause.
The problem is here that the liquidated damages are sought to be claimed, if I can put it that way. If I'm wrong about this, the liquidated damages are sought to be claimed against the tortfeasor, which conversely...
Well, so they were a Network Rail. I don't think this particularly harms you, because you're still able to say that here the clause was the daily hire rate, and that there are going to be many cases where there is a spare car available. It's not necessary, you could accept, that you have to inquire into the actual facts every time somebody suffers a £200 charge, and that it's reasonable to have would be reasonable to have a charge that wasn't the daily hire rate, but was some kind of genuine attempt to predict what a typical loss would be.
Yes, it damages for loss of use, which is what Clause 16 says it is calculating. It is not calculating, and your lordship is absolutely right to say that what is recoverable in tort is genuine loss. And since the tortfeasor is not party to the contract, then genuine loss still has to be proved. Loss of use.
So it should have been in Network Rail.
Well, in that...
because it's an analogous situation. So on that view, the train company should have had to prove their actual losses.
But Network Rail was forestalled by the agreement that was a genuine estimate of the actual losses. I'm not criticising anybody in Network Rail for dealing with it in that way, but that was common ground in Network Rail. And so there was no inquiry into which route was adopted to get to that estimate. But it was accepted that that was genuine. And that was a reasonable estimate of loss. Will your lordship forgive me for that? My lord, may I fill in with some points that I've left out on the way, a rather discursive set of submissions. We do make the point, and it's a point that starts in bailment, but then carries over, we say, into the tortious liability, that the repair period in this case was after the hire to Mrs. Armstead had ended. She used the car during the rest of the hire period, even though there'd been the accident, and then she returned it to help her at the end. History doesn't relate exactly what happened, but it appears that her own car, her original car, was repaired, and so she simply took the car back. And she took the car back having used it. And it follows, therefore, that the Clause 16 claim is not brought in respect of loss of use during the hire period,
No.
when she was bailee. And it was common ground that she didn't bring any claim for loss of use. Effectively, she was bringing a claim for loss of use for help hire's loss of use. And as my lady points out, what she was claiming and what she has been claiming is simply the contractual liability.
Yes.
And what Mr. Williams' submissions effectively amount to is to say, as against the tortfeasor, you can just look at the contractual liability and claim that. And that effectively, that contractual liability, be it never so unreasonable, is recoverable because it's a contractual liability.
Well, supposing it is a reasonable pre-estimate of loss, would you say it was still irrecoverable because the car was repaired after the end of the bailment?
If it's a reasonable estimate of loss, so say we have
if it's a reasonable estimate of loss, then on the facts of this case, would she be able to recover it under Clause 16?
Quay credit hire amount or quay...
Let's start again. Assume that Clause 16 is a reasonable pre-estimate of help hire's loss.
Yes.
So Ms. Armstead is liable under Clause 16. Can she recover it from the tortfeasor?
Yes, but the route by which she gets
So the fact the repair period was after the end of the bailment doesn't affect anything?
She doesn't get it in bailment. At that stage, she'll get it in... that stage, she gets it in negligence.
Her cause of action is negligence?
The cause of action is negligence,
yes. All right.
That's correct.
No, well, she gets it in negligence, doesn't she?
Yes.
Yes.
Maybe she would get it in negligence even if it was a loss that occurred before the end of the hire.
Yes. I think there's quite a lot of these references in your written case to a claim in bailment, but this isn't a claim in bailment at all. This is a claim.
No, it's a claim in negligence, and we've made that
To be a bailee.
Yes.
Yes, we've attempted to make that distinction clear.
Right.
At some stages in the papers, that has been confused because of the bailment aspect of it. What is important, though, is that she has to show that it's her property.
Oh,
And she...
Do you dispute that?
No.
No. I mean, she as the hirer of the bailey,
She has the
sufficient titles to sue in negligence.
Yes, and she does that as bailee.
So I think you now say, and I think that Mr. Williams also says that really the only thing between you is whether Clause 16 should be taken as a reasonable pre-estimate of loss. I mean, Mr. Williams made that fairly clear that was the key issue in his submissions, and we've now reached a situation where it's the key issue in your submissions as well.
I think we're not far away from that, yes.
Yes. Williams is smiling. You're both smiling.
But I think, I'm not sure these hearings ever leave everybody smiling, but
Not when the judgment comes out.
the difference between us is how you get to liability in the tortfeasor. We say that has to be based upon establishing reasonable loss to help hire from the point of view of help hire, and cannot simply be based on the contractual liability. It's Lord Richard's point entirely. If you could show that it was a reasonable pre-estimate for the purposes of showing help hire's loss, then that would lead to success for help hire. You cannot show that in this case. There's been no attempt to show that in this case, and indeed the findings of both the Recorder and Lord Justice Stingelmann's are inconsistent with that proposition.
And is the question whether it's a reasonable pre-estimate of loss a purely factual question? I ask because there's a fairly trenchant finding by the Recorder that it wasn't reasonable as between the claimants and the defendants insured, which isn't, I think, quite the same as saying it wasn't a reasonable pre-estimate of loss by help hire. But he then goes on to say, I'm looking, it's on page 157. I've already considered the reasonableness as between the claimant and the defendants insured.
Yes.
The losses arising under clause 16 between the claimant and helpline. I consider these to be unreasonable because they do not reflect the actual loss to helpline by reason of the car being off the road. So he seems to have found it wasn't a reasonable pre-estimate of loss between helpline and the claimant, help hire and the claimant. And if I'm not mistaken, Lord Justice Stingelmann's, well, he does. That's one of his
Yes.
grounds of
Yes.
55.
of appeals.
Yes.
I'm just sorry, I suppose I'm asking whether those are concurrent findings of fact in the courts below.
Well, we say there are findings of fact that this was unreasonable as an estimate of damage for all the reasons given both by the Recorder and by Lord Justice Stingelmann.
Paragraph 56 in the Recorder's judgment, he restates his conclusion and says he's already considered the reasonableness. Could you just point us to the paragraphs where he actually addresses the reasonableness?
Paragraph 28 is one of the paragraphs relevant from these excerpts. And there are two important facts about which there's no dispute. Firstly, the claimant was not using the hired car as a profit-earning chattel on her own behalf. Secondly, the claimant advanced no claim for her own loss of use of the vehicle. During the course of the arguments and the preparation of this reserved judgment, I've asked myself what in reality is the loss in respect to which the claim is being advanced. The only loss was that of help hire, who lost the use of a profit-earning hire car. By its hire agreement, it seeks to provide a mechanism to compensate it for the loss of use of that vehicle. The claimant is claiming the contractual sum for help hire's loss of use. I can see no sensible analysis which leads me to conclude otherwise than the reality is that the claimant was claiming for and on behalf of help hire to compensate them for their loss of use. However, it is of course convenient for help hire to pursue its claim for loss of use through the bailee. This is because through the claimant, it stands to recover a greater sum for loss of use than it would have had it sued the defendants insured directly. This makes for an uncomfortable analysis and is one which, though analysed in a somewhat, I think it meant short manner or somewhat truncated manner, Deputy Judge, District Judge Fawcett found surprising. And then
he's not quite there addressing whether clause 16 is a pre-estimate of loss. He's actually looking at the actual loss and saying, well, that's what help hire could have recovered. And so the question is whether Ms. Armhurst can recover more. And that actually ties in with what he said later on in 56, because he talks about the actual loss there.
Well, what also ties in is at 41.
41.
The hire car damaged in the Index accident was owned by Help Hire and was one of a number of vehicles available for hire as part of its business of vehicle hire. Claim by Help Hire for loss of use against the defendants insured for the period when the vehicle was undergoing repair and therefore not have been available for hire could not have been founded on the sum owing under clause 16. Such a loss would surely have amounted to relational economic loss had I accepted Miss Muller's argument based on a literal application of the Charles Wilson-Percy definition. Ms. Muller was at that stage counsel for the claimant, because it only occurred because of the relationship between Ms. Armstead as the immediate physical victim of the tort, as the claimant asserts, and Help Hire the claimant. Rather, the assessment of damages for Help Hire's loss of use of a profit-earning chattel would have followed the approach identified by the Court of Appeal in Beechwood. So what he's saying there is that the assessment of damages on a realistic basis would have been the Beechwood assessment, which is the capital tied-up assessment.
And is that ultimately your position on the damages for loss of use?
The reality of the damages for loss of use, yes, that's all they've proved.
So you say that that is the total amount that Miss Armstead can recover?
Yes.
Which is the capital depreciation?
Yes, the Beechwood assessment.
So
they've made no claim for that. And 44...
Yes, 44, I think.
Understandably, as Help Hire is not the claimant, I received no evidence which sought to quantify a loss of use claim, adopting the approach in Beechwood. It would not be amiss to conclude, however, that Help Hire's loss based on such an approach would be significantly smaller than that which, if the claimant is successful on this appeal, they will recover through her claim. Mr. Tannock argues that the effect of the claim is to attempt to circumvent Beechwood and should not be allowed. I'm left in...
It's all equating, isn't it? I mean, you might as well look at Help Hire as if they were bringing the claim. But it's not Help Hire bringing the claim. I mean, this is all perfectly sensible if one's looking at Help Hire or the claimant.
But the reality is that Help Hire are relying upon their contractual right to insist that Miss Armstead brings a claim to recover more than Help Hire could have claimed.
I don't think you can say that...
Well, I'm not sure about that.
Miss Armstead shall be treated as if she is Help Hire.
Well, doesn't the court have to look at the reality, which is that this is a contractual liability that was never claimed from Ms. Armstead until 2 years after the event and shortly before these proceedings were started.
You say they shouldn't be able to get indirectly. Well, they can't get directly. Otherwise, they're using it effectively as a sort of ruse to get around the principles of damages.
Exactly.
And they can do it in every case.
And that's what's said both by the recorder in this case and by the Court of Appeal. And by District Judge Fawcett, Deputy District Judge Fawcett. So at every level, this has been seen as exactly your Lordship describes it, as a ruse to use Ms. Armstead's name using the contractual mechanism of suing in her name, which they're entitled to do under the contract, in order to recover more than Help Hire actually could have obtained for Help Hire's loss.
Well, that
Ms.
would be
Armstead
all right.
never...
It wouldn't be a ruse, would it? If Clause 16 was a genuine and reasonable attempt to assess likely losses.
Sustained by help
That's
hire, yes.
Network Rail.
Yes, yes, to sustain by help hire, exactly.
The argument is presumably, well, you look at the losses actually suffered by help hire in a case such as this to determine whether the clause was a genuine and reasonable attempt to assess likely losses.
Yes, that's absolutely
That's the
right.
way it's relevant. I don't think we need enter into the world of ruses. And to be fair, I don't think this case has really been defended on the ground it's a ruse and virtually a sham.
It hasn't been defended on the basis that it's a sham as such.
I mean, if your case was that that help hire would actually never seek to recover this sum from Miss Armstead, well, that's a case you might have run, but I don't think that's ever been run.
It's never been run specifically,
Maybe
you can't say.
There's a principle. The principle could also be stated as saying that they shouldn't be able to recover by way of recovering from Miss Armstead and her recovering from the tortfeasor more than they've actually lost and could recover by direct claim.
Yes.
Doesn't have to call it a ruse, but in principle, the two measures of damages you say should be the same.
Should reflect each other. And it's even more the case when they've described in clause 16, which is the lost clause, the recovery clause, that the damages as damages for loss of use. And unless they are in fact reasonably describable as damages for loss of use, that is an unfair description, and one which shouldn't be relied upon as sustaining a claim by Miss Armstead for a loss that has never in fact been suffered.
Your case, which I think succeeded in front of the recorder, was that nothing more than interest plus depreciation could have been recovered by help hire, and therefore, and for that reason, without going any further into the facts, clause 16 wasn't a reasonable pre-estimate of loss.
Yes.
Now,
Right.
it was submitted this morning by Mr. Williams that that wasn't the right approach in relation to a revenue-earning asset. Do you want to say anything about that? I'm not sure we go any. I'm not sure we get any. Do we get any different analysis by Lord Justice Dingemans, or is it all on the basis that you succeeded on that as the legal basis for a loss of use claim by a commercial enterprise in the position of help hire?
Well, I think his is a bit more sophisticated because he's saying you could take into account a sort of average rate and the fact that sometimes you might have been able to hire it out and sometimes you wouldn't.
Yes, Mr. Williams is saying swings and roundabouts are fine.
No, but Lord Justice Dingemans is saying that some sort of average or calculation might have been okay, but here it wasn't because it's assuming that every time you can hire out, you can get the daily hire rate, and that can't be a pre-estimate. That's
Yes.
So he's not tying it to you only ever suffer a loss, which is the loss of interest and depreciation.
No, but he is saying,
you
have to prove
you can't assume it's going to be the full hire rate every time.
Exactly.
You cap it at 30 days.
Yes, and the capping it at 30 days doesn't necessarily make the difference.
Yeah.
But while I don't wish to make hay on the pejorative use of the word ruse, the difficulty in principle for the claimant in this case is really the difficulty that left the recorder feeling uncomfortable, which was that the use of the name lending clause, if I can put it that way, was enabling help hire effectively to recover more than they could actually have recovered by the creation of a contractual liability in Ms. Armstead, which would enable the argument put to me by my lady, Lady Simler, that that's a contractual liability and therefore recoverable without more. And if it's not a pre-estimate of loss, we say as a matter of principle, it's not therefore, I use the word pre-estimate probably the wrong way, if it's not an estimate of the loss that was actually suffered, then it's not recoverable from the tortfeasor. And the reason is relatively simple. It's an analogy with rules about privity.
Sorry, analogy with?
With rules about privity. It is that Mr. Galewski is a stranger to the contract. And if I can take the argument to its absurdity to test it, it means that, apart from statutory control, any figure could be put in the daily hire rate if it wasn't going to be collected or demanded, and any figure could be recovered under Clause 16. And indeed, Clause 16, although a bog standard clause as it's been described, doesn't have to be tied to a daily hire rate. It could simply
be a number.
Set out a number, and the number could be as high as you like. And if it was a contractual liability, in which, of course, Ms. Armstead probably has no interest because she doesn't expect to pay it. She expects there to be recovery from the other side, and if there's no recovery, she doesn't expect to be stung with it. And the argument that Mr. Williams puts that it's a proxy for a reasonable rate because it appears in the clause is simply wrong. Help hire could have any number of commercial reasons, some legitimate, some less legitimate, for putting a high number in Clause 16. They could do so simply for a commercial reason that they wanted to maximize their bottom line. They could do so because they thought that nobody would actually object to it because the hirers in the position of Ms. Armstead weren't going to look at it. They were only going to look at the fact they were getting credit for hire until it was recovered from the other side. And it simply isn't a proxy for a reasonable estimate. They could do it simply because other companies were doing the same. And the question then arises, and this is a policy reason, and I'd prefer it to be described as a policy reason than a jury point, but it is, why should Mr. Gillespie and his insurers be left to pick up a claim for a loss that has never actually been sustained in the absence of any proof of such a loss, with an impact on Mr. Gillespie's premiums in the future, when there's no real basis for it, when he hasn't agreed it, as Ms. Armstead, by signing up to the agreement, has. But that's a matter for her. And it comes back to the concession that Mr. Williams rightly made based on Network Rail, that reasonableness and foreseeability are intimately connected. I don't think I can go as far as supplying the authority that my Lord Burrows challenged us to supply before the lunch and adjournment, that foreseeability and reasonableness were effectively the same, because they're plainly not, because the tests are different. But nevertheless, they are intimately connected. And one can say it is not foreseeable to a driver driving around the roundabout in Banbury that somebody will crash into that they will crash into somebody and cause an accident and suddenly find themselves liable for a very large sum.
Well, it is reasonable. The test is not just one of foreseeability. Lots of things are foreseeable, but reasonableness introduces a value judgment of some kind.
Indeed, it does.
Which constrains
yes.
the test. It's not merely a matter of likelihood that's going to be the case.
Exactly.
The fact that everybody else is doing it too may make it likely, but it doesn't make it reasonable.
Exactly. So maybe Mr. Williams' concession is a little
When
too
we say
far.
everybody else was doing this, so we were shown Avis and Thrifty.
Yes.
So the clauses are similar, but your point is that the actual charges made under those clauses are considerably higher than it would be with Avis and Thrifty, is that?
More than double, yes.
Yeah.
Well,
But that's not your main point, though.
It's not my main point. My main point
in
is
the event, these are apples and oranges, aren't they? Because
Yes.
the other contracts are standard rate.
Yes.
This contract is credit.
Yes.
What we
Precisely
haven't
so.
seen are other credit hire contracts, standard form.
I'm not running a case that this is.
But I assume they're similar. Let's work on that assumption.
But the logic of your solution would just as well apply to an Avis type of contract.
Yes.
If Avis maintained a car pool and couldn't show that there were no cars in the pool when the accident
Yeah.
occurred.
Yes, it would.
Except that the sums are much smaller.
Yes.
Well,
I would
yes.
say that the
yes.
principle applies, but the practical effect may
And the
be
assessment of the reasonableness may be different on that account alone.
Yeah.
The problem here is the concatenation of circumstances that enables a credit hire company to charge all these extra points, which they're not able to charge under the Dimmond and Lovell decision, in the absence of an assessment that they've actually suffered any loss, and claim that against a tortfeasor who's a stranger to the contract.
But you say the same would be true if Avis, leaving aside the credit hire rate, was seeking to recover under their clause, which
Well,
is the basic hire rate.
subject to the point that my Lord Richards put to me, which was, of course, that because the sums may be smaller, the reasonableness may lead to a different conclusion. Because
No, but assuming that sometimes they have a spare car available, even if not every time, then it would be not a reasonable estimate of their loss to say that they get the full hire rate. You'd have to discount it by the prospect that they would have a spare car available, and so the loss would actually, in many cases, be a lot less.
well, one spare car or 90% of their fleet. I mean, these are assessments of reasonableness.
Of course, it would be fact-specific, but...
Yes. That, I concede and indeed rely on the fact that it would be fact-specific. But the central point of principle is who's the defendant.
I'm afraid we pushed you around from pillar to post. Lord Marks,
My lords, you have. It's been
time to get back onto your plan submission.
yes. I don't want to cover ground that I've already
Very
covered.
helpful, if I may say so.
Well, that's very kind. I've been.
About 30.
What I don't want to do is leave out points that I was going to make and have made in a different order, or haven't made rather. My lord, we do rely upon the point that this was economic loss, where it's loss that doesn't flow directly from the physical damage. And that ties back to all the points that I've been making. If the loss is not a loss that's consequent on the physical damage and is only consequent upon the contractual structure,
That's a different argument, isn't it?
this is a new argument, but it responds to
This is a
the fourth ground of appeal.
causation argument. It's different from the foreseeability argument.
Yes. It's a question of whether it's economic loss, and then there's the question of relational economic loss. Relational economic loss being variously described, but what I think can be agreed is that it may be consequent in a loose sense, in other words, happen because of physical damage. But nevertheless, its origin is not, its genesis is not the physical damage, but either the property or the relationship, in this case, the contractual structure. And if the loss arises as a result of the contractual structure between, on the one hand, Armstead and Help Hire, and then also, just that contractual structure. If that's the loss that Armstead has suffered, and Help Hire have relied upon that structure to enable Armstead to sue, then that loss is not recoverable from the tortfeasor because it's not directly consequent upon the physical damage sustained in the accident. All that happened in the accident was that there was damage to the vehicle. That gave rise to a need for repairs, and it gave rise to a loss of use in Miss Armstead and or Help Hire, depending on the time at which you look at the loss of use. In fact, in this case, it didn't give rise to any loss of use in Miss Armstead, And there's a question over whether it gave rise to any loss of use in help hire who simply had their car under repair for 12 days. And if that didn't make any difference to their business, that was no loss. My Lord, if I may adopt the process adopted by Mr. Williams and let Mr. Tannock deal with the Manchester Building Society and the Meadows and Carn checklist with the remaining 10 minutes that I have for us.
Please do.
I'd first ask him if I've left out any crucial points in my area of responsibility. He says not, so I rely on that.
Well, he can make them now anyway.
Mr. Tannock.
Thank you, my lords. Thank you, Lord Marks. I will try to take the Manchester so-called cross-check at a quick canter, so to speak. With respect to the first question, the actionability question, is the harm, the loss, injury and damage, which is the subject matter of the claim, actionable in negligence? Well, this is addressed by the Court of Appeal in their decision at paragraph 59. No need to turn there, but it's at bundle page 134. And the Court of Appeal held that it was not actionable because the harm suffered was consequent on what it described as an internal arrangement between help hire and Miss Armstead. And in my submission, and this is one of the points that Lord Marks was making most recently, but for the credit hire contract, Miss Armstead would not be liable for the amount demanded of her by help hire and now claimed from Mr. Galowski based on the daily credit hire rate. Nor would she, for example, be liable for help hire's loss of profits, which this rate that is claimed includes.
But that is true every time a victim of a tort incurs a contractual liability. They wouldn't be liable if it wasn't for making the contract.
Well, my lord, if you're driving a car, a hire car, and it is negligently damaged by another driver, but for a clause like clause 16, as long as you've not been negligent or contributing to negligence, you're not liable to the car hire company for their full rate or indeed in any amount. It's the tortfeasor who's liable in tort for those. We accept that Miss Armstead would be able to recover help hire's actual loss, which is the Beechwood assessment. And it's our case that she cannot use her contract with help hire as a license in tort to claim more than is reasonable. That's the network rail point. And our case is that the amounts that fall outside that are amounts that arise not from the harm or the loss or the damage that's suffered as a consequence of the court, but as a consequence of the contract. As a further point in this respect, there would also be an element of double counting. And that's because credit hire charges include charges to cover legal costs and interest or the provision of finance. And for a court to allow Miss Armstead to recover those costs in addition to these from a tortfeasor would result in double counting. And Lord Hoffman makes this point in Diamond at page 407E, and in the bundle that's page 591. With respect to the second question, the scope of duty question, what are the risks of harm to the claimant against which the law imposes on the defendant a duty to take care? As my starting point, I take the hopefully uncontentious position in tort that consideration of the kind of loss for which a claimant is entitled to damages as compensation is relevant when assessing the scope of the duty of care. So this is as Laws Oliver said in Kapara Industries at 651F. It's page 543 in the bundle.
Page?
It's 543 in the bundle at 651F. It has to be borne in mind that the duty of care is inseparable from the damage which the plaintiff claims to have suffered from the breach. It is not a duty to take care in the abstract, but a duty to avoid causing to the particular plaintiff damage of the particular kind which he has in fact sustained. In my submission, what a driver does is a driver assumes responsibility for the task at hand, which is driving the motor vehicle. A motorist assumes responsibility to other road users to avoid carelessly causing physical damage to their persons or property. But the motorist doesn't assume responsibility for matters falling outside that task, such as avoiding other users becoming liable for whatever they may have agreed in respect to their vehicles in any amounts with third parties. So Mr. Gillespie wasn't under a duty to protect Miss Armstead from what Lord Justice Singh in the Court of Appeal referred to as a bad bargain. That's a paragraph 66 of that judgment. Further, I asked rhetorically, why should Mr. Gillespie pay the full credit hire rate? These are the Beechwood and Network Rail points again. Turning to the third question, the breach question, did the defendant breach his or her duty by his or her act or omission? My answer to this, in light of what I've already said, is that the insured driver was in breach of a duty to drive carefully and was responsible for the physical consequences of his act and for economic consequences that were directly flowing from that act. But in my submission, he wasn't under a duty to avoid the liability faced by Miss Armstead, and he isn't liable to compensate for that. As to the fourth and fifth questions, I'll take them together because I think in this case they can be taken together. The first is the factual causation question. Is the loss for which the claimant seeks damages the consequence of the defendant's act or omission? And the duty nexus question, is there sufficient nexus between a particular element of harm and the subject matter of the defendant's duty of care? Well, in my submission, in short, there was no sufficient nexus between the duty of care to drive carefully and the Clause 16 liability demanded from Miss Armstead and now claimed from Mr. Gillespie. The loss that is claimed is a contractual liability, and the contract or its terms can't be said to be a consequence of the negligence.
I mean, you're not claiming that it's not a factual consequence of the loss of the damage, are you? Or are you?
No, I'm not claiming
that seems to be a hopeless suggestion.
Yes.
Given the normal but-for test. It's all a question about legal causation, isn't it? Or
yes, it's
however you want to describe it.
It's
that it be treated as something, as a consequence for which the defendant is responsible.
Yes.
But as a matter of fact, in the physical world, there is a
contract. Yes, the contract is there. The contract's been entered into. Absolutely accept that. There was an accident, of course. Absolutely accept that. But I don't accept that the perhaps as a matter of causation, I don't accept that all of the quantum that is claimed is caused by the accident or is reasonable. So the Beechwood test takes us back to what was the actual interest and depreciation on the asset, and Network Rail, what's reasonable to claim. So in my submission, those elements of the loss that exceed the Beechwood, Birmingham and Network Rail analysis are caused by Miss Armstead entering into what might be termed a bad bargain, not, for example, the actual rate for hire of a car or the market rate for property rental as an ELMA or the accepted quantum of loss as a Network Rail.
Well, Mr. Tunnett, we're getting to a point where we've got to let Mr.
Thank you, of course.
Have his 15 minutes.
Thank you, my Lord. Well, the sixth question is the legal responsibility question. And with respect to that, just to reinforce what Lord Marks said, that the loss, Miss Armstead claims, she admits that it needs to be reasonable in order to have been foreseeable by Mr. Gillespie. And all we have in my submission is the BHR evidence of Mr. Pistorius showing that rate to be something over double the usual rate. With that, my Lords, thank you very much.
Thank you very much indeed. Mr. Williams.
Well, my lords, my lady, the prophet Malachi tells us that proceedings at the last judgment will be like a refiner's fire. And we see today that proceedings in your lordship and your ladyship's court may also be like a refiner's fire, because the point in contention really has been refined quite a lot. And really, as we foretold, the overwhelming issue that remains in the case we submit is Clause 16, an unreasonable clause in the sense that was discussed in Network Rail, plainly unreasonable, not a fair estimate of the train company's loss and the various ways in which we saw it put. Now, in saying that it's not, my learned friend really focuses on 2 points, which were the points also focused on by the Lord Justice below, namely absence of 100% usage, and secondly, the fact that Helpar's full contractual rate will be discounted in some cases as between Helpar and the tortfeasors, which its business model relies upon payment being obtained from. And we've never suggested that those are unfair points. But we take first as our starting point that it's precisely in order to avoid debates about usage and about average recoveries, which could give rise to relatively complex calculations involving disclosure, potentially of commercially sensitive material, and not simple questions. Because it's not just enough to say to Helpar, well, what's your usage rate? Because Helpar will have Rolls-Royces and Ferraris. It will have completely commonplace cars like Fiestas, and it might have something in between like Minis. Nor for anybody who's been involved in the car hire world, in addition to retail hires, there is an extremely vigorous secondary hire market where these hire companies hire cars to one another. So actually, to determine what a loss of profits would be in very small cases like this, where very often the cost of the dispute would be far more significant than the amount being claimed, because they're all in the small claims court, that is something which is to be avoided at all costs. And the way that is done by Helpar, and as we've seen by other hire companies as well, is they have a formula where they essentially fix the compensation that they will be paid during a period when their car is unavailable at the pre-agreed contractual price. So something which between they and their customer is something we say simply can't be characterised as unreasonable, but for a short period. And we saw that in all the 3 agreements we looked at, it was 30 days in all of them. And I don't, although I know it's a cliche, I don't shy from repeating the swings and roundabouts. Yes, Helpar's usage rate will not always be 100%, but it's equally unlikely that they or Avis or anyone else maintains a surplus fleet of Minis which are standing idle. But equally, there will be cases where the period the vehicle is off the road will be considerably longer than 30 days. And having in mind this commercial context, as I say, the potential for completely disproportionate disputes, we say that what has been done is not obviously unreasonable in the way that Lord Justice Jackson puts it in the Network Rail case, and so does not fall into the category of that which is too remote. And my learned friend's criticisms to the contrary, in my respectful submission, really expose why clauses like Clause 16 shouldn't be adequately undermined. Because my learned friend says that in order to prove cases like this on the small claims track, it's not even just enough to have the disclosure and such like of usage rates and so on, but Mrs. Armstead has to put her own means into contention so she can demonstrate whether in her case Helpar's recovery would have fallen into the Langton and O'Connor category of cases, or whether it would have fallen into the category of cases where recovery is only made at a Diamond and Lovell discount. Again, that is the very purpose of clauses like Clause 16 are intended to avoid, and in our respectful submission, that is a perfectly reasonable purpose. I do repeat my rhetorical question from before. Could you characterise Clause 16 as a penalty, for example, because it doesn't give credit for the fact that some hires will be, some utilisation periods will be less than 100%. In our submission, you could not say that because of that it has the characteristics of a penalty, not least because it is offset by the 30-day cap. So we maintain the position that this was not an unreasonable clause. I obviously will mention the burden of proof in a moment. Just before that, the reference to Diamond and Lovell. Diamond and Lovell is about the case of what you can recover post-accident when you've incurred higher charges by way of mitigation and you bring a claim for special damages. And it, in conjunction with Lagdon, shows that you can't recover an excess over conventional hire rates resulting from credit charges unless you had no choice but to incur them because, for example, you couldn't put down your credit card at Avis when they preload it with £1,000 or whatever they would preload it with. But clearly we're not here in that situation. What we're dealing with here is a loss resulting from a contract pre-existing that's been triggered by an accident. And so the only relevance of Diamond and Lovell, we say, is whether the fact that in some cases Help Hire won't recover 100% of its charges means Clause 16 is plainly unreasonable. And you have our submissions as to why. Well, we say it's not, because there are other factors that justify Clause 16. Its salutary role in avoiding disproportionate disputes and the fact liabilities are only very short term. Now, my learned friend showed you that in Network Rail, Lord Justice Pill cited the Diamond case, but all Lord Justice Pill cites Diamond to show is that a contract is not conclusive. But, of course, we have not asserted as part of our case that the contract is here conclusive. But equally, Lord Justice Pill certainly does not say the contract is not relevant. He merely says that it is not necessarily conclusive. And just in the only passage I will invite the court, if I may, to turn back up, it's page 751. Paragraph 79, this is a paragraph my learned friend relied on. He said it's accepted the sums claimed are as between the respondents and the operator. 79, my lord.
79, thank you.
Top of the page.
Yes, thank you.
It's accepted the sums claimed are between the respondents and the operating companies reasonable. It doesn't follow the figures must be accepted because the respondents are monopoly suppliers. However, Schedule 8 has obviously been drafted responsibly and with a view to achieving a fair result in the public interest between the parties to it. So Lord Justice Pill finds that there is no reason in that case to go behind the contract because between the parties to it, it was drafted responsibly and in a view to obtaining a fair result. Well, as we have seen in this case, between the parties to the hire contract, namely Mrs. Armstead and Help Hire, as we saw from visiting my learned friend Mr. Tannock's skeleton in the lower court, it is fair to say it might have been a concession that's through gritted teeth, but nonetheless it is a concession that no case is maintained that as between Mrs. Armstead and Help Hire this clause is unreasonable. And as I understood Mr. Marks, I'm so sorry, Lord Marks, again, perhaps through slightly gritted teeth, and perhaps with an air of willing to wound but unwilling to strike, no maintenance as between Mrs. Armstead and Help Hire, the clause is unreasonable. But on that basis, the Network Rail case shows if it's reasonable between the parties to the contract, then it's unlikely to be unreasonable between the claimant and the tortfeasor. My Lords, I said I would say something about the burden of proof. We've looked at this over the short adjournment. And perhaps surprisingly, the law appears to be uncertain on this issue. It's not in the bundle, but obviously we can file it or your lordships can unleash, or your ladyship can unleash your assistance. But McGregor 8002, 8-002 of McGregor has a discussion pointing out there are authorities going both ways. Although McGregor himself makes the submission, which one understands, that it is ultimately for claimants to prove their case, and obviously I accept that. But even assuming against me... Well, but that begs the question of whether it's part of the claim or it's a defence. Well, quite. And it also, but even if you assume the position against me, and I obviously say that you shouldn't, but if you were to assume the position against me, I say you have to here determine what has or has not been proven against the background that this case remarkably comes to your lordships and your ladyship from the small claims track. So the sort of evidence which it has is obviously not the evidence that you get before Mr. Justice Aikenhead in the commercial court. And it comes against the background of it being common ground that Clause 16 is a standard clause in a standard contract which is commonplace throughout the industry. So no suggestion it's outlandish, and where certainly there is nothing in the defence to put help hire to any sort of proof through Mrs. Armstead about usage rates and things of that sort. All that is said are the points under the Consumer Rights Act and the points about a penalty which was subsequently abandoned. My Lords, in the last few minutes, I have to confront the point that was put to my learned friend about findings of fact being made. I don't accept there were findings of fact in any meaningful sense about the help hire agreement being unreasonable. Firstly, the fact finder in this case was Deputy District Judge Fawcett. He certainly made no findings of fact, and he couldn't because none of these points about not a genuine pre-estimate weren't explored. And insofar as the recorder made some robust statements, I think the court sort of became alive to this during Lord Marks's journey through the recorder's reasonings. But with great respect to the recorder, the robust way in which he expresses himself is completely exploded by him wrongly accepting the measure of loss is Beechwood. So he's saying Clause 16 is unreasonable because he thinks help hire jets get interest and depreciation, something which is plainly wrong. Lord Justice Dingemans accepts it's wrong. And that is the passage from the judgment my learned friend took you to, and I won't take you back to it, but for the court's note, page 153, paragraphs 41 to 43, absolutely clear. The recorder with respect to him is operating on a completely false predicate. The ruse, it isn't a ruse, and it does bear saying we are talking about a tiny subset of cases where somebody who's had one non-fault accident then has another non-fault accident while they're still in a credit hire car. This is not a matter of massive economic significance between the parties, which is doubtless the reason it's ended up here from the small claims court, not from some sort of test case, which there have been many over the years when there actually have been points of profound principle arising out of these cases. But the fact... There must be
some reason why the legal costs requiring hearings in 4 courts have been incurred. Well, otherwise, sensible parties, as one normally assumes insurers are, would have split the difference. Well, I suppose that the difficulty is... There must be some wider significance. Well, obviously these cases will go on happening. From your client's point of view. Yes, well, these cases will go on happening until somebody resolves the law, and over the years they will mount up. But I'm told, for example... So this isn't a complete one-off? No, in fact, I suspect there's no harm in telling the court that I understand from those behind me that they think there may be about 50 cases awaiting this. But it's not... For example, when Diamond and Lovell came to this court, I think there were hundreds of thousands of cases were stayed in the county court pending Diamond and Lovell. So it's nothing on that sort of scale. But the point about it, I mean, my learned friend was good enough to say that he doesn't jump on an attractive forensic turn of phrase about a ruse. But it certainly cannot say that it is a ruse because the loss which is being claimed is not precisely the same loss that would have been claimed absent the hire contract. Because if Network Rail hadn't had a contract in the Carnarvon case, the measure of loss would have been totally different. And of course, the whole way in which the contract operated in Carnarvon was to facilitate indirectly a recovery by train operating companies who could not themselves have brought a claim at all because that would have been relational economic loss. So the fact that the way in which I put my case leads to a recovery, which I don't shirk from acknowledging, would be different from that, which if Help Hire brought the claim itself. In my respectful submission, it simply proves nothing. And it certainly doesn't prove that Clause 16 is unreasonable between the parties to the contract. My Lords, those are my submissions, unless I can assist the Court further, my Lady as well.
Thank you very much. Well, the Court is most grateful to all 4 counsel for your stimulating submissions and your readiness to engage with energetic debate initiated from the bench, all of which has been of the greatest assistance needless to say, we will take time to
Thank you, my lord.
accept our judgment.